A partition lawsuit is a lawsuit filed with the court asking the judge to force a sale of the property that you own with at least one other person. Any co-owner of a property has the right under law to file a partition lawsuit and request that the property be sold so that the owners can get their fair share of the proceeds from a sale. You can think of a partition lawsuit like the divorce of a property. No, sometimes just sending a demand letter, or if the parties have already discussed a possible resolution, then filing a lawsuit may not be needed. Parties can agree mutually that without filing a lawsuit to sell the property or to have one of the owners buy out the other owners for their interest in the property. In these cases, the attorney's job is really to negotiate the terms of the agreement, draft a formal settlement agreement, drafting necessary title documents that need to be recorded, and also to then possibly coordinate with a real estate agent and a bank if a new loan will be taken out to buy out the other co-owners. It is always advised when possible that the parties settle between themselves and reach a mutually agreeable resolution. When one party refuses to negotiate or settle the dispute of ownership, this can significantly increase the cost for all co-owners involved. Our attorney's fees could go up, the court costs of course will go up, and you may have to require the hiring of a court referee and of course the real estate agent. Our attorneys have successfully negotiated hundreds of real estate disputes, including partitions, without the need of a lawsuit. Although the filing of a partition lawsuit is fairly straightforward, a lawyer that specializes in partition lawsuits will know how to protect your rights, how to work quickly and efficiently, and how to maximize the proceeds from a partition dispute. The big areas that we see attorneys make mistakes on that don't specialize in this area are the offsets, reimbursements, and accounting issues. Even judges can sometimes make mistakes regarding the accounting portion of a partition lawsuit. So having a specialist attorney can ensure that you receive maximum proceeds from a sale. There are also some surprises that can appear in a typical partition lawsuit that a partition attorney needs to be prepared for. Arguments related to bankruptcy, family law, living trusts, mortgage laws, financial elder abuse, adverse possession, quiet title, and slander of title are just a few examples of other related arguments that sometimes overlap and are critical in a partition lawsuit. For example, there are very complicated quiet title arguments that can sometimes be made to recover 100% of title if for a client in certain circumstances. And in certain circumstances, the other side could be responsible for paying all of your attorney's fees. So it is important that you hire an attorney to handle your partition lawsuit that has a lot of experience with these types of lawsuits. If the parties agree to a sale or a buyout without having to file a lawsuit, then the process can take up to 6 months. If the parties do not agree, then the process could take up to a year or longer depending on how busy the court is with other cases. However, a motion can be filed shortly after the filing of the lawsuit to ask the judge to sell the property now and then decide who gets how much of the proceeds later on at trial. Yes, this is very common. When one party wishes to keep the property, then they will have the opportunity to buy out the other side's property interest. If the parties cannot come to an agreement, then a real estate agent will be needed to list and sell the property for sale. And then at that sale, one of the owners can be the highest bidder and buy out all of the other owners' interests in that property. The first step is usually sending that demand letter to see if you can negotiate a settlement. Then the second step would be to file the lawsuit for partition along with any other arguments that we want to include in that lawsuit. The third step is then filing what's called a lis pendens, and that is a notice that a lawsuit is pending, and that's recorded onto title of the property. The fourth step is then usually breaking up the joint tenancy. If the property is in joint tenancy, we usually advise to go ahead and break that up by filing a deed to the co-owner to themselves. The fifth step is usually filing a motion for interlocutory judgment, and that's where the judge makes a ruling to sell the property now and decide the other issues later. Judges will almost always grant the interlocutory judgment request. This means that a real estate agent will need to be hired, and if the parties are not cooperating, then the court referee will also need to be hired. That court referee is going to be charging both parties or all parties that own the property their fees will be paid out of the lawsuit. A court referee is an attorney that specializes in partition lawsuits and has the power of the court. The parties usually then exchange written discovery. Parties can also depose each other and other witnesses or third parties to support their case. After discovery is completed, then the parties usually sit down for mediation and try to settle the dispute if the dispute still hasn't been settled by then. However, you can also try to settle the dispute immediately after filing a lawsuit or before filing a lawsuit, as discussed before. If the parties cannot agree on how to distribute the proceeds, then a court trial will need to be held on that issue specifically. A jury trial is usually not necessary or provides any kind of advantage to either side. We generally recommend, therefore, a bench trial where a judge decides, and these trials usually last a day or two, so they're not that long. When the property is sold by a real estate agent, our clients may have the option to hire us to also be the real estate agent for the sale. By doing this, our clients can get a discount on their attorney's fees. It also helps because when we are hired to be the real estate agent, we of course don't have to call the agent for updates, get past information back and forth, so that should cut down on some of the attorney's fees charged. So that is an opportunity to go ahead and bundle your services, and that is the process for a partition lawsuit. Our attorneys have experience with hundreds of partition lawsuits, both negotiating and going to court, going to trial on these cases. Myself personally, I've overseen over 100 partition lawsuits. In addition, I've worked on, and our team has worked on, lawsuits that are similar to partitions, which are like quiet title, financial elder abuse, adverse possession. So all of these cases have a lot of similarities, and our law firm and myself have a lot of experience with these cases specifically. I think it's really important that you hire an attorney that works on these kind of cases every day. The attorney's fees can range anywhere from $5,000 to $50,000 or more, depending on whether the lawsuit is needed and how long the lawsuit goes on for, and if there's trial. If the parties cannot agree on anything and there are arguments about who gets how much, then the fees, of course, can be more than $50,000. However, for most of our partition lawsuits, the average is approximately between $15,000 and $25,000 in attorney's fees, where most parties eventually do settle and agree at some point. With the median home price in Los Angeles County almost at $1 million currently, the typical 5% real estate agent fee then comes out to about $25,000 per real estate agent. That's something to consider and hopefully avoid if the parties can agree to a buyout. These fees are also sometimes something to consider when a sale is needed. In most partition lawsuits, a client can pay our fees out of the sale of the property. However, a percentage fee is added on top of our hourly rates and will increase the total attorney's fees paid. Therefore, we always recommend that our clients, if they can pay up front, to do so, or if they can qualify for a low interest loan from a bank to cover our attorney's fees, that would be advisable. If the other side does not hire an attorney, then yes, half or a portion of your fees can possibly be paid by the other side. If the other side objects or obstructs the sale of the property, then they may also be penalized by the court, and some of your attorney's fees may be paid by them. Also, they could be penalized by having to pay a higher proportion of a court referee fees. And of course, and if a court referee is required for your case, they will also have to pay some of that. There are also some other arguments like slander of title, financial elder abuse that can support you charging the other side to pay your attorney's fees. Under a standard partition lawsuit where the title is not in dispute, the chances of success are very high. It is rare, however possible, that one co-owner of a property might have significant offsets and reimbursements that cover all of the other co-owner's equity interests, meaning that a co-owner may not be entitled to any of the proceeds from a sale because they haven't been paying the rent, they've been taking out loans on the property, or other offsets and accounting arguments that basically cover all of their equity. Offsets and reimbursements can include mortgages paid, repairs paid, and then taking out a large loan and not sharing those proceeds with a co-owner. That's why it's very important to evaluate all of these offsets and accounting issues and bring all of your evidence and facts to your attorney so they can evaluate. Any and all title documents or other documents related to promises or agreements related to the property you should provide. Sometimes the parties will text each other with new terms related to the property. So any of those text messages or emails and any receipts for housing expenses that you may have made, including a down payment for the property, so the purchase documents, all of those documents that you have with escrow, bring those in. To help keep down the costs, we always recommend that our clients put together a chronological timeline of all important facts and information, and that they put together their documents also in chronological order and mark them as reference to the chronological timeline. By doing this, our clients can save a lot in attorney's fees and make sure that all of the relevant arguments can be made by the attorney based on the facts and evidence that our clients have.